Well, my first question to you would be, are you sure that you offered the evidence on the record? What happens a lot of times in trial is that a limine motion is made by the parties, and there are rulings by the trial court that require you to then approach the bench before you offer the evidence. Keep in mind, a limine motion against your evidence does not preserve error. You must make sure that at some point during the trial, you offer this evidence and you get a ruling by the trial court that excludes the evidence. That doesn't just grant a limine as to the evidence, but excludes the evidence. If you have gotten that ruling and the trial court did exclude your evidence, then the next step is you have to get this excluded evidence into the record somehow. Most people call this a bill of exceptions or an offer of proof. The rules of civil procedure detail how to do this, but in short, let me explain it. The first step, in front of the judge and outside the presence of the jury, and before the jury is read the jury charge, you need to put this evidence into the record. You can do this by putting the witness on the stand and asking the witness the questions. You can also do it by simply dictating into the record what you believe the evidence would have shown to the jury. Once you've done this, re-offer the evidence to the trial court, which means, again, ask the court to change its mind. Ask the court to allow the evidence to be considered by the jury. After you get that additional denial by the trial court, you have preserved error. There are other things you should consider when your evidence has been excluded. So my best advice is, if you do have questions as to how to preserve error when your evidence has been excluded, contact your appellate lawyer.